Speaking as a Ghanaian with no legal training, I believe that the refusal of the Electoral Commission chairperson to testify in this election petition leaves a very bad precedent for the future. I disagree with the suggestions of our justices that an election petition is akin to any other civil litigation, and therefore an EC chairperson whose functions go to the heart of our democracy can, by a legal sleight of hand, avoid accounting for her stewardship in an appropriate forum such as the highest court of the land. Our legal team, led by Mr. Chachuchi Kata, put together our case in a clear manner, which left no one in doubt about the issues that were at stake. Apart from seeking to ensure compliance with the Constitution and for the true choice of the people of Ghana to be respected, the petition sought to provide opportunity for transparency and accountability in the management of our electoral process. But no one who followed the proceedings of the Supreme Court will be surprised with the judgment pronounced a few hours ago. Much as I'm aware that we are legally bound by the decision of the highest court of the land, the Supreme Court of Ghana, I disagree with the process of the trial and the ruling of the court. For the avoidance of that, I say, much as I'm aware that we are legally bound by the decisions of the Supreme Court, I disagree with the process of the trial and the ruling of the court. Ladies and gentlemen, our 1992 Constitution says very directly in Article 125, Section 1, that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. I believe that law should not be an instrument for partisan purposes. I also believe that the rule of law should mean one rule for all. What anchors the rule of law is equality and fairness to all, irrespective of creed, background, or political coloration. Justice, we must remember, is rooted in moral foundations. Ghanaians will always remember that moment when my lead counsel, Mr. Chachuchi Kata, quoted from the Holy Bible, urging the justices of the Supreme Court to be faithful to their judicial oath and their conscience, only for the lawyer representing the second respondent to argue for the exclusion of God in this matter. And yet in the courts of Ghana, including the Supreme Court, we swear on the Bible or the cross, as we also do with the Holy Quran, to speak the truth and nothing but the truth. Ghanaians will also remember, and this will go into history, this 2021 election petition for that profound moment when the chairperson of the Electoral Commission opted to evade public scrutiny. Everything was done in this trial to prevent the Commission from accounting to the people in whose name they hold office. Requests for interrogatories were dismissed. A request for inspection of documents in the possession of the Commission was turned down. The request for admission of facts was ignored. And worse still, she was aided by her counsel and the court to avoid explaining to the good people of Ghana from her own testimony under oath in a properly constituted court of law the errors that she herself admits to have committed in the declaration of the 2020 presidential election results. This is a clear stab in the heart of transparency and accountability to the sovereign people of Ghana. Whatever the reasons for not allowing Mrs. Jane Mensah to testify or answer any questions, it leaves an embarrassing stain not only on our justice delivery system, but also on our nation's electoral system, which has deepened the grave doubts harbored by many Ghanaians about the true outcome of the December 2020 presidential elections. Ladies and gentlemen, the motto of Ghana's Electoral Commission is transparency, fairness, and integrity. Principles that the key actors of the Electoral Commission clearly failed to live up to on this occasion. The refusal to account to Ghanaians further sets the worrying precedent, and I do really worry about this dangerous precedent that may allow other heads of state institutions to adopt an approach of opacity and non-accountability in their work, just because they know they can rely on unconvincing interpretations of our laws to shield them from scrutiny in the near future when they are held to account. I hope and pray that time will prove me wrong.